In this video, I'd like to spend a few moments talking about medical decision-making and a flowchart for how the substitute decision-making process works. The scenario that we're looking at would be one where we have a crisis situation, then someone needs to make a decision regarding your medical treatment. It's a time-sensitive matter, and it is typically going to be an emotional situation as well. As a result, most people are not readily prepared for it, and there's great potential for conflict within the family about what should be done and how those decisions should be made, because there is associated with all this the responsibility for making the decision, and in worst case scenarios, the liability for making that decision. So there's 4 questions that we need to use to sort through this. First and foremost, can you make healthcare decisions for yourself? Do you have an agent appointed to make decisions in the event you can't? Is your condition terminal? And then, do you have a living will? Let's put this together and we'll see this kind of an approach. Let's take the questions one by one. Can you make healthcare decisions for yourself? And the first thing on this is, do you have the ability to communicate? And secondly, related to that is, do you have the mental capacity to process the information necessary to make a decision? Now, under the law, you are always presumed to be able to make that decision. And so we have that situation where the question arises, do you really know what you are doing and how do you express that? So back to the flowchart. There we go. Can you make decisions for yourself? Well, if it's clear that you can, then it's fairly simple. Yes over here, and you speak directly to the physician to make those kind of decisions. If you aren't, however, if the answer is no, then we have to go to the next question. Do you have an agent? And what we're referring to here is an agent that you have named under a durable power of attorney for healthcare. In Iowa, that is Chapter 144B. Durable power of attorney just simply means a document that authorizes an attorney in fact to make healthcare decisions for the principal, that's you, if you are unable, in the judgment of your attending physician, to make those decisions. And attorney of fact just simply means the person you have designated that they will act as your agent for that purpose. But let's spend a little bit of time here. Healthcare means any care, treatment, service, or procedure to maintain, diagnose, or treat an individual's physical or mental condition. Healthcare does not include provision of nutrition or hydration, except when they are required to be provided parenterally or through intubation. Note also, under the code, healthcare decision means the consent, refusal of consent, or the withdrawal of that consent to healthcare. So back to our flowchart. Can't make decisions for yourself, and do you have an agent? If the answer is yes, then the agent talks to the physician and is able to express your wishes through them. If, however, the answer is no, we need to go to the next question. Is your condition terminal? Terminal conditions are defined in the code again as an incurable or irreversible condition that, without the administration of life-sustaining procedures, will, in the opinion of the attending physician, result in death within a relatively short period of time or a state of permanent unconsciousness from which, to a reasonable degree of medical certainty, there can be no recovery. Life-sustaining procedure means any medical procedure, treatment, or intervention, including resuscitation, which meets both of the following requirements. 1. Utilizes mechanical or artificial means to sustain, restore, or supplant a spontaneous vital function. 2. When applied to a patient in a terminal condition, would serve only to prolong the dying process. And then life-sustaining procedure in subparagraph, he goes on to identify what was mentioned before about nutrition and hydration. So where does that put us in the flowchart? You can't make your own healthcare decisions. You do not have an agent. And let's say that your condition is terminal. We then go to the question of, do you have a living will? Living will technically under the Iowa Code is known as a declaration, but here's what it says. If I should have an incurable or irreversible condition that will result either in death within a relatively short period of time or a state of permanent unconsciousness from which to a reasonable degree of medical certainty there can be no recovery, it is my desire that my life not be prolonged by the administration of life-sustaining procedures. If I am unable to participate in my healthcare decisions, I direct my attending physician to withhold or withdraw life-sustaining procedures that merely prolong the dying process and are not necessary to my comfort or freedom from pain. And again, those key terms were described on the prior slide. And now that comes directly from the Iowa Code. So, working through the chart, not able to make decisions for yourself, no agent, and you do have a living will, then we go to a direct conversation with the physician. But let's say that so that takes us to the procedure under 144A.7. Life-sustaining procedures may be withheld or withdrawn from a patient who is in a terminal condition and who is comatose, incompetent, or otherwise physically or mentally incapable of communication and has not made a declaration in accordance with this chapter, if there is consultation and written agreement for the withholding or the withdrawal of life-sustaining procedures between the attending physician and any of the following individuals who shall be guided by the express or implied intentions of the patient in the following order of priority, if no individual in a prior class is reasonably available, willing, or competent to act. Let's just look at that for a moment. Very long, complicated, partial sentence, and just highlight a few things here. One, we're talking about, again, a terminal condition, has not made a declaration. There needs to be consultation and written agreement between the attending physician and any of the following individuals who are guided by the express or implied intentions of the patient. And for this list on the next slide here, you'll see that it's the order of priority. Who are those? We start with an attorney in fact, if they have been designated, the guardian, then the patient's spouse, an adult child of the patient, a parent, or an adult sibling. The thing that often surprises people here is that a spouse is not the top of the list. Moving on, back to our flowchart. Can you make your own health decisions? No. Do you have an agent? No. Is your condition terminal? Now we're going to say yes. And you don't have a living will, so we have used that procedure in 144A.7. But let's say, for example, that your condition, take that out. Let's say your condition is not terminal. Then our next step is to go to a court-appointed guardian. Court-appointed guardian is in the probate code, chapter 633. And what we're looking at here is the guardian may be granted the following powers, which may only be exercised upon court approval, and that refers to consent to the following: the withholding or withdrawal of life-sustaining procedures from the protected person. Thing we want to note here again, may only be exercised upon court approval. So, once again, here is our overall chart. 4 questions. Can you make decisions for yourself? Do you have an agent? Is your condition terminal? And do you have a living will? The difference in all this is whether or not your wishes are known at all, or whether or not we have to use the court to interpret any statements you have made to get an indication of what your wishes are. So how do you know what your wishes are? The best thing you can do is to prepare a durable power of attorney for healthcare. And this is also known as a healthcare power of attorney, or sometimes referred to as a healthcare proxy. Secondly, making a living will can be a great way to make sure that there is some family member or someone you trust to work with your physician to express your wishes and get those accomplished. 3 other documents that you may have heard of: the do not resuscitate order, the out of hospital do not resuscitate order, and the physician order for scope of treatment. These are 3 documents that only can be prepared with the assistance of your physician, and those are only with regard to a specific condition, not a general admonition that you don't want something. Finally, there is a procedure under the guardianship and standby guardianship provisions in the probate code. And then there's also a thing called a medical directive that we don't see a lot of, but some physicians make them available. It is essentially a checklist that allows you to identify specific treatments that you may want in the event you have a specific condition. So my recommendation to you is this: the most important document that you can have is this durable power of attorney for healthcare. It grants legal authority for someone else to make your decisions, but recognize that it doesn't say how they are to make those decisions. You really need to have a conversation with your particular agent. There are some very specific requirements for the validity of that document and for its execution, and it is the responsibility of the principal to provide notification of a healthcare provider of the terms of the principal's durable power of attorney for healthcare. So what are the next steps? This video has only briefly introduced the durable power of attorney for healthcare and the living will, the 2 best documents that you can prepare in advance. There are some additional videos that I have prepared and will make available to you upon request. They provide a more detailed review of each document and include a step-by-step walkthrough of the document as well. Finally, there's another video that talks about some of the potential problems that there may be with any type of healthcare directive this way, and just some things to think about in that regard. So please contact me with questions, comments, or suggestions. And I strongly encourage you to do this, if not for yourself, then for your family. Thank you for your time and attention.